Hello, hello, hello again, everyone. Estate planning attorney Paul Rabley, another action-packed live stream we're going to give you here this evening. This one's all about the blended families in estate planning, yours, mine, and ours. But you know what? The issues I'm going to address this evening, they're not just for those blended families. Really, the issues I'm going to address, many of them also affect just I'm going to say the regular, traditional one marriage with children scenario as well. So everybody who's been married, everyone who has parents, has grandparents, or is married, you'll all be able to benefit from the information we share here this evening. So, hey, out there, I'm Paul Rabley. I'm an estate planning attorney. I several years ago founded an estate planning law firm, national estate planning law firm called America's Estate Planning Lawyers. If you want to know more information on that, or to request an initial estate planning design meeting with me where we can talk about your situation and figure out the easiest way to make sure things go exactly how you'd want them to go, feel free to check out the description below. Let's jump in. Also, big hello to Larry. Always good to see Larry from California in there just about every time. So thanks for showing up, Larry, and enjoying the relationship. All right. Also, hey, Tad, and hey, Ann. Ann's there just about every evening as well. So nice to see the little emoji from Ann or Auntie. So that's great. All right. We'll go back to the chat once I finish this presentation. I'm not on a time schedule tonight, so I'm gonna go through the information. I like to boom, 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 hit it hard, and then we'll take a look at the chat. And for all those questions that you pose, those experiences that you share, maybe some comments, look forward to going through those one at a time, and addressing the ones that seem appropriate and timely and on the subject, and do my best to address all those as well. So that's what I love about the live stream, is at least we're able to have some chat interaction, much better than me just recording something and then throwing it up there. Okay, so I'm going to divide this presentation really into 4 parts. One, I'm going to define for estate planning purposes what a blended family is. And then number 2, we'll talk about some of the potential problems that blended families face. Number 3, we'll talk about how to resolve the blended family issues, the various issues that come up. And then number 4, give you a case study of a married couple, maybe getting married later in life. Each of them has a couple of children, how they address the typical issues. So, and then after that, we'll hit the chat. Okay. Hey, Johanna, just thought I'd throw that in. Good evening. All right. What is a blended family? I'd say most people define a blended family is when you have a married couple and one or both of the spouses have one or more children from a previous marriage or previous relationship. These days, 2024, you see a lot more of that for whatever reason. Don't even really need to get into the dynamics of the reasons we see a lot more of that, but it's just we do. And so I guess you could also, for estate planning purposes, really include in that group those couples who have no children, but they have different beneficiaries. They're like, well, if we both pass away, I know I want my part to go to these people on my side of the family, and I know you'd want your part to go to your side of the family. So a lot of the blended family issues also have to deal with the married couples with no children, and then like I said before, many of these issues that I'll talk about in the blended family situation, they affect the traditional one marriage with children scenario, particularly when it comes to how the surviving spouse, after one spouse dies, can potentially get influenced or adversely influenced into doing something that neither spouse would have intended them to do, but because that surviving spouse maybe just wasn't as sharp and didn't have the capacity that they had previously had, they made a mistake. And sometimes those mistakes are hard to undo. So again, my point here, but maybe the last time I'll say it, many of these blended family issues, they affect the traditional or the one marriage with children scenario as well. Okay. And you're in a blender family. That's interesting. So, wonder what a blender family is. Maybe was that intentional or unintentional? Maybe you want to clarify that. If you need to, I've just never heard of a blender family. Maybe you use your blender a lot, and that's a bad dad joke. All right, so we've defined what a blended family is. Number two, let's talk about what some of those potential estate planning problems are with blended family. The easiest problem to explain and the easiest potential problem to understand, although it goes a lot deeper and we're going to get into some depth. But to just start to realize the basic problem, Fred and Ginger, husband and wife, maybe they got married in their 40s or 50s and 60s or 60s, and they each had one or more children. And so they feel like they need to get their estate planning in order. So just kind of unknowingly and without really get into the depth that they should get into, they write what I call "I love you" wills, and which is they each write wills and they love each other. So their wills say, Fred's will says, "Of course, when I pass away, I leave everything to Ginger." And Fred's will says, "Well, yeah, if Ginger dies before me, then I leave my things to my two kids." Let's say Fred and Ginger each have two kids. So Fred's will says, "Of course, I'm going to leave everything to Ginger." So and then he doesn't want to exclude his children. So of course he says, "If Ginger dies before me, I leave what I own when I die to my two kids." Ginger's got her own kids. And so what happens is Fred dies. And what happens? Well, Fred's "I love you" will said he leaves everything to Ginger. But now Ginger owns everything. She owns what was hers before Fred died. So let's say Fred and Ginger had $4 million. It could be $400,000. It could be $40 million. But Fred and Ginger had $4 million. And let's just say, for fun, to keep it simple, each of them owned half of that. Each of them owned $2 million. So when Fred dies, Ginger has her $2 million. But Fred, who loves Ginger, left his $2 million to Ginger. And now this whole idea of, well, Fred's will says if Ginger dies before him, Fred leaves his estate to his two children, but Ginger didn't die before him. So Fred died and he left his estate to Ginger. Ginger now has her $2 million, and she also just inherited Fred's $2 million. Now Ginger has the entire $4 million, and she lives on for several more years. And guess who's going to get, now that Ginger owns it all, she has the ability, because she owns it all, to leave the entire estate, her half, Fred's half, which she inherited. She has the ability to leave her entire estate to whoever she wants it to. She has two children. Fred had two children. After Fred dies, Ginger didn't quite stay as close with Fred's two children. Fred's two children didn't contact Ginger on Happy Mother's Day and on Ginger's birthday, and that offended Ginger a little bit. So what does Ginger do? Well, Ginger sets it up so that when Ginger dies, the whole thing goes to Ginger's two children. Fred's two children, because he died first and Fred left it all to Ginger, Fred's two children are excluded. They don't get zip. They get zero. Maybe Fred and Ginger maybe Fred in particular, didn't really understand the consequences of leaving everything to that surviving spouse. So now maybe Fred and Ginger had an agreement. Maybe Fred says, "Well, I love Ginger and I love her kids and she loves my kids." And so they have this informal understanding where Fred says, "Ginger, I'm going to leave my estate to you. And I just trust you that when you pass away, you're going to include my children." So sometimes it works out that way. In many, many circumstances, it doesn't, because those relationships change after Fred dies. It all goes to Ginger. Ginger winds up changing things and leaving it to her children or her children and grandchildren, excluding Fred's children. Sometimes Fred might leave it all to Ginger, and Ginger does initially start out with the intent that when she dies, she's going to leave it all to the four kids, Ginger's two and Fred's two. But perhaps later in life, maybe when Fred died, Ginger was 70. And now Ginger's 85 and her capacity is not as good. And maybe Ginger. Ginger meets a nice man. Maybe he's a few years younger. Maybe he's 75 and Ginger's 85, and he sweet talks Ginger into, maybe you should change things, and maybe you could leave me part of your estate. And so, what I say unintentionally, I really mean, Ginger was influenced into leaving the whole $4 million or part of it to Ginger's next spouse or boyfriend or significant other. Now, I realize there are laws in place, so if someone does adversely influence another, like Ginger, into changing estate documents, there's laws in place to protect people, but it's hard to undo those things once someone exerts influence over another and then the other dies. It's hard to undo that adverse influence. So sometimes that happens. So now you're probably starting to get an idea of what some of these issues are. Sometimes, again, not necessarily the blended family, but the traditional family. Dad will pass away, and he does leave things to his children. Let's say dad and mom had 3 children together, and sometimes dad dies. He leaves things to the children, or perhaps some leaves things in trust with the children to get it when the surviving spouse dies. But the children, after dad dies, for whatever reason, say something like, well, yeah, our dad died, and you know what? We just wanted to keep it simple. The lawyer asked us to do it, so we just signed everything over to mom. And we knew the children say that we would get it, in a few years when mom passed away. But dad dies, children inherit some assets or some portion, and they quote unquote sign it over to mom. Now mom's got the whole shebang, and mom makes a mistake later in years and leaves it to whoever, and the kids are excluded. So you see that sometimes. Children sometimes they come to me, and it's killing me. They're like, after dad died, we need to undo this, Paul. But I'm like, did you sign anything? They're like, well, yeah, we just signed something because they asked us to, but it got all turned over to mom, and we got to undo that. And I'm like, let me get this straight. You actually signed documents turning your inheritance over to your mom, and now you're asking me to do something about that? So you got to really be careful what you sign, what you do, after someone dies, because some people think that when they sign stuff, it doesn't matter. They can just undo it later. And that's just not the case. All these documents, all these signatures that take place as part of an estate settlement, they have meaning. All right, here's another big problem with again, blended families, but not only blended families. And it has to do with IRAs. It has to do with traditional IRAs and 401ks, but it also, the same problem is with Roth IRAs and Roth 401ks. But with traditional IRAs, there's always this, what are the income tax consequences going to be? So there are significant income tax consequences to traditional IRAs. Those consequences are whoever gets those distributions, whether it's the IRA owner, their spouse as their beneficiary, their kids as their beneficiaries, whoever gets distributions from those IRAs, they're going to pay income tax on it. So there's just more involved in the how do you set up your IRAs, more involved than the who's going to inherit it, but also not only who's going to inherit it, but what's their relationship with the previous IRA owner, which will trigger how quickly the beneficiary has to take distributions from that IRA and include that as part of their income. So because all of that, it seems to be just customary or normal, or everybody does it. Any married person with an IRA just seems to tend to name their spouse as their beneficiary. So Fred and Ginger, Fred has $1 million IRA, and he's 55 years old, and he knows he could leave that IRA name. And in fact, everybody's telling him, oh man, name your spouse, name your wife, Fred, as your beneficiary on your IRA. Because after you die, she can treat it as her own IRA and she won't have to start taking distributions for another 20 years. And then those distributions will be small, it'll keep growing. And then, she can take those distributions over her life expectancy. By all means, delay tax by naming your spouse as your primary beneficiary, they tell Fred, who's 55. Well, that's fine and dandy, and all that's true if Fred, who's 55, has his $1 million IRA and he dies and he names Ginger as beneficiary and she's 50 when he dies. Boy, she can wait another 25 years before she has to take distributions. Think how much that IRA will grow. That sounds like a great idea. But Fred has 2 kids from his prior marriage and Ginger has 2 kids. So when Fred transfers his IRA to Ginger, and maybe it does grow and grow and grow and grow and grow, well, guess who Ginger's going to name as the beneficiary of what was formerly Fred's IRA? She's going to name Ginger's 2 kids, or maybe even her next husband, whatever the case may be, but it certainly won't be Fred's 2 children. So you see that a lot where it is customary for married couples to solve these problems in part by leaving things to kids, in part by leaving things into a trust for the spouse, with when the spouse dies, those assets reverting back to the children of the first spouse to die. But you see the problem even more with IRAs, because when someone's opening up an IRA account, they seem to be more focused on establishing the account, moving assets in there, growing the IRA. And it's just the beneficiary designation that they set up when they open that IRA account. It's just an afterthought, it seems. So they just name spouse as primary beneficiary, kids as contingent beneficiaries. And the problem doesn't rear its ugly head until the surviving spouse passes away and the children of the first spouse to die realize, uh-oh, we're not getting anything. And then they raise all heck, and there's just nothing they can do. So, all right. Another potential problem with the blended family, but again, with the traditional family, but the problem rears its ugly head more often with the blended family. It's who's going to manage Fred's money if he gets to a point in his life where he's not able to sign his name, handle his accounts, take his IRA distribution, manage his investment portfolio. And if Fred and Ginger got married later in life, and maybe Fred and Ginger got married when they were 60, and Fred has 2 adult children who are close to Fred and who are both financially very responsible, and in their mind and Fred's children's mind, they're kind of thinking, I wonder if Ginger is conniving to get at my dad's money. And so who Fred names on his financial or general or durable or power of attorney, call it whatever you want, all becomes really important here. So let's say Fred has his $2 million. He gets sick, and he needs to pull funds out of his accounts to provide for his care. He's married to Ginger, but he's got his $2 million. She has her money. Ginger's like, he's not going to spend any of my money on his care. Maybe he needs to go into an assisted living facility. Maybe it's $10,000 or $15,000 a month. And maybe the kids agree that, he really shouldn't be, doesn't need to spend that much money. Maybe one of the kids is saying, my dad, Fred, he can move in with me, and I'll give him better care than he could ever get anywhere else. And so there's an argument there on how Fred's money should be spent for the rest of Fred's lifetime. And then we go back to, okay, Fred did a power of attorney. Who did he name on his power of attorney? Let's say he named Ginger, and the kids are going to go, uh-oh, Ginger's going to go through that money like she's never seen it before. And that'll leave nothing when dad dies. Or what if Fred named one of his children as his first agent on his durable power of attorney? Then Ginger's going to say, wait a second, that's my husband. I ought to be able to manage his money if he's incapable of doing it himself. That should be me. And so she's mad that Fred had appointed his son. Well, if Fred appointed his son, that he obviously did that intentionally, especially if he did that while he was married to Ginger. And so there was a reason Fred appointed his son. Maybe if he appointed Ginger first, it was just an afterthought, because that's what husbands typically do, is they appoint their wives and vice versa. But that can be a real tricky issue with the blended families as well, on the who gets named on not only just the financial powers of attorney, but all those healthcare legal documents as well. All right, so let's talk a little bit about how to resolve some of these blended family issues. So the typical blended family is maybe a couple gets married later in life. Later in life could mean they're in their 30s and getting married for the second time or the third time. When I think of kind of getting married later in life with estate planning issues, I tend to think of people who maybe get married when they're 60, for example. They come into the marriage with assets, they come into the marriage with children. And so what kinds of legal issues will rear their ugly head that we need to nip in the bud before it gets ugly? So one of the first things couples should consider prior to getting married later in life, particularly if each of them has their own children, is whether to do a prenup. And typically the kind of typical prenup is, hey, especially in community property states where anything, where things acquired and salaries earned during the marriage or community property deemed owned 50-50, regardless of whose name they're in. A lot of couples who get married later in life, bringing in assets, bringing children into the marriage, will agree on something like this. Let's have a prenup. What's mine is mine, and what's yours is yours. And really, those prenups for couples who are getting married later in life, they're not necessarily what happens if we get divorced driven. They're more, let's make it real clear who owns what, so that when we die, there's no question about what Fred owns. There's no question about what Ginger owns. So it's real easy to settle the estates of each of the parties when they pass away. So that's a consideration of whether to do some kind of prenuptial agreement prior to the marriage in order to establish ownership of certain things. The next issue that needs to be addressed in this blended family situation is what happens when one spouse dies. Fred and Ginger, $4 million. Each has $2 million. Fred dies. What happens to Fred's $2 million when Fred dies? Fred has 2 children of his own. He has a lovely wife. What does he do? Okay, so generally in the blended family situation, we typically don't see this traditional Fred leaves it all to Ginger, because we talked about that problem. Ginger potentially will leave it to her kids, excluding Fred's children. So Fred's got a couple of different options here. I'd say the most common option is Fred leaves his part. We'll call it $2 million. Ginger has $2 million. Fred has $2 million. Fred leaves his $2 million to a trust because he wants to provide for Ginger out of his $2 million. He wants Ginger to be able to benefit from that, for the rest of her life, because no telling how long she'll live and no telling what needs she may have. And then it's in a trust after Fred dies. Let's say when Fred dies, Fred's $2 million goes into the Fred trust. And then when Ginger later dies, assets in the Fred trust revert back to Fred's 2 children. So that's a way for Fred to provide for his spouse, but make sure his children are protected. Now, there's some really important decisions that Fred and Ginger, because Ginger might die first as well, but I'm going to focus on Fred now because Fred's a little older and he's a man and he thinks he's going to die first. But you never know. So there's some important decisions Fred has to make when leaving his estate in trust for Ginger. One decision is who's going to be the trustee of that trust. Is Ginger going to be the trustee by herself? And so if Ginger's the trustee by herself, we're looking into the trust provisions to see if Ginger has the right not only to the income from that trust, but does she also have the right as the trustee to take distributions from the Fred Trust after Fred dies, perhaps for her health, education, maintenance, and support, a common standard we see in these trust instruments. So then now it can get tricky, because if Fred leaves his assets to a trust for Ginger and then to Fred's kids when Ginger dies, and Ginger has the right to take distributions from the trust to herself, then that could get a little tricky, even if she's limited to only taking those distributions for her health, education, maintenance, and support. So on the trustee decision, does Fred name Ginger and maybe one of his kids as co-trustees, where they both have to agree to provide distributions out of that trust to Ginger after Fred dies? That certainly provides some checks and balances, but is that going to be too much protection for the kids? Because Fred's child will never authorize a distribution to Ginger out of the Fred Trust after Fred dies, because now you're just depleting the future inheritance of Fred's children. So the trustee decision, when people leave, when a married person leaves their assets to a trust for the benefit of their surviving spouse, the trustee selection becomes very important. Also, what becomes very important is when is Ginger entitled, when is Ginger entitled to take distributions from the Fred Trust after Fred dies? And so, or maybe even more clearly here, when is the trustee or co-trustees, when are they permitted to make distributions to Ginger for her health, education, maintenance, and support after Fred dies? So this could be set up perhaps one of three ways. There's really an unlimited number of ways, but let me focus on the main ones. Maybe there's some tax reasons. While we're really not talking taxes right now, there's some tax reasons for Fred to make this what I call a Q-tip trust. Don't get too hung up on the fact that I'm using Q-tip. It's a tax term, but it means that Ginger will get the income from the Fred Trust after Fred dies for the rest of Ginger's lifetime. If Fred had a really large estate, setting it up that way would qualify for what's called the unlimited marital deduction for estate tax purposes. So there'd be no estate tax that would be required to be paid when Fred died, even if his estate was larger than the estate tax exclusion amount for 2024, which is $13.61 million. Okay, so Q-tip is a tax thing, but you know what? It works well for non-tax reasons as well. So Fred leaves his $2 million estate to a trust for Ginger, says she gets the income for life. So if it's a $2 million estate, there's probably a mix of real estate, stocks, bonds, cash, and other assets that make up that $2 million. And if Ginger gets the income for life, let's say that the income every year is maybe $30,000 or $40,000 off of that $2 million, interest, dividends kind of thing, not necessarily capital appreciation. So Ginger gets that income. The principal stays preserved. Now, Fred has some decisions to make when he sets this up. Does he want to set it up so that the trustee or co-trustees can make principal distributions for the rest of Ginger's lifetime for her health, education, maintenance, and support? Or does he want no principal distributions to be made to Ginger after Fred dies, and he wants to limit her benefit to just getting that income off of the $2 million for the rest of her lifetime? Or does he want to do maybe something in between? As long as she doesn't remarry, the trustee can make principal distributions to Ginger for her health, education, maintenance, and support. But at the moment that she remarries, her right to principal distributions stops. So then she'd only get the income for life, and that principal would be preserved for Fred's two children to get it when Ginger dies. And that Ginger's next spouse couldn't influence the trustee, whether that was Ginger or otherwise, from making distributions to Ginger to benefit Ginger's next husband's life. Okay, got a lot going on here. This is good stuff. Looking forward to getting to the chat here in a little bit. Okay, so here's some other important decisions Fred and Ginger need to make when they're setting this up. So Fred and Ginger may be saying, you know what? Fred may be saying, he says, Ginger, we have $4 million. Each of us has $2 million. Fred says, when I pass away, I want my part to go in a trust for you, Ginger. But you know what, Ginger? After we both pass away, I think everything should be four ways equally for our collective four children. We each have two children. I'd like I'd like us to set it up so the four children inherit equally after both of us pass away. So there's some decisions that married couple has to make. They can do it one of two different ways. So let's pick on Fred now. Let's say, everybody's convinced he's going to die first. So he could say, in this attempt to try to treat the four children exactly the same, regardless of who dies first and who dies second, Fred could say, when I die, I leave my estate in a trust for Ginger. And then when Ginger dies, what's left of my estate or what's left of my trust must revert back to our collective four children. And that sounds great. That sounds, Fred's treating the four children the same. And when they set it up so that when the surviving spouse dies, even the surviving spouse's share gets split four ways. Great plan. That's the plan, to leave everything to the four children equally, even though one may die first and one may die second. The potential problem with that is, if Fred dies first and leaves his $2 million estate to the Fred Trust, which provides that when Ginger dies, the Fred Trust goes back to the four children equally, which sounds great. Now, Ginger, who has her own $2 million estate, she could change her part so that it goes just to her two children, messing up we want it all to go to the four children after we both pass away equally. So under that scenario, Fred's part goes to the four as intended, but Ginger changed things after Fred died. So her part, her 2 million or whatever it is, winds up going to her two children. So again, the first spouse to die, their children get the short end of the stick. So the other way to do it is for Fred to say, when I pass away, I leave my estate in trust for Ginger. And when Ginger dies, the Fred Trust reverts back to Fred's two children. But then Ginger has her own 2 million, and Ginger may live for another 20 years, and her 2 million may appreciate, or it may get depleted. And when you do it that way, it's very, very likely that the four children will not all inherit equally. One spouse's child will wind up getting more, in some cases much more, than the other spouse's child, based on appreciation of assets from the date the first spouse died to the date the second spouse died, and how much the surviving spouse spends, and other issues as well. So a couple of issues there with blended families we need to look out for. Okay, and then same thing with resolving the power of attorney issues. Most third parties out there are not a fan of the joint power of attorney. There's a lot of financial institutions out there that kind of have a policy, and policy is kind of their own internal regulation, that they won't honor a power of attorney if it appoints two people that have to act together. So if Fred says, boy, I don't know who to name on my financial or durable power of attorney, I probably, I'm thinking I may need to appoint my wife Ginger, because she might be offended if I don't appoint her. And in fact, quite frankly, she should probably appoint me, Fred says, because I help her handle her money. But Fred says, yeah, well, I can make an argument that I should appoint Ginger as my financial power of attorney. I know my son, who's an accountant and is very professional and organized. I know he would do a good job if I appointed my adult, mature, responsible son to be my power of attorney, ahead of my wife, Ginger. I don't know what to do, Fred says. So Fred thinks, well, let me just appoint both of them. They can work together. Well, that could be a problem, because go to your bank, for example, go to your brokerage firm, go to your financial institution and say, hey, if I'm incapacitated and I had signed a power of attorney that required these two people to work together, will you guys honor my power of attorney so that both of them have to act together to manage my financial affairs? There's a pretty good chance they're going to say, no, we don't do business that way. we'll only deal with a power of attorney when one person and one person only has authorization to act on your behalf. Or they may say, yeah, we'll honor it. And that's the bank teller saying that. But then when it happens and they run the power of attorney through the legal department, they come back with a different answer. So, all right. So be real careful with your power of attorney issues, not only for financial matters, but for healthcare matters as well. People in blended families, do they name the spouse? Do they name the adult children? Those are conversations that you have to have and decisions that you need to make. All right, let's go back to the IRA because I mentioned it's worth mentioning twice. It is very common for Fred and Ginger who have their estate, and in Fred's will or in Fred's living trust, he says, when I die, I leave my part of the trust, or I leave my estate in trust for Ginger. I name so-and-so as the trustee. When Ginger dies, it goes back to my kids. That's common. But Fred's will or Fred's living trust doesn't address where Fred's IRA goes. Let's say he has $1 million IRA. And Fred could say, I name as the beneficiary of my IRA the Fred Trust, which says that Ginger gets the greater of the income from the trust, or Ginger's required beneficiaries that are necessary once she reaches, let's call it age 75. And when Ginger dies, what's left out of that goes back to Fred's children. Fred could do that. Two problems with that. One, when you name a trust as a beneficiary of a traditional IRA, everybody gets confused. The beneficiaries get confused. The lawyers get confused. The accountants get confused. The financial advisors and the brokerage firms get confused because there are complex rules that dictate when the income tax has to be paid when an IRA owner has named a trust as the beneficiary of that IRA. So that's one problem, just complications that arise. I'm not saying that can't be overcome, but everybody has their opinion on what should happen, or everybody else says, what in the heck is supposed to happen here? So we don't like that chaos when somebody dies, but sometimes we get through it when we do that. The other problem is if Fred names as the beneficiary of his IRA a trust, and typically that trust would say to avoid these penalties for failing to take required distributions, that trust would say Ginger gets the greater of the income from that trust or her required distribution. It's a see-through trust. I'm not going to get into all that right now, but let's just say after Fred dies, Ginger's got to take required distributions. If she lives long enough, her required distributions are going to wipe out that trust. Of course, when she takes the distributions and starts piling up money, she's going to leave that to her kids. So by Fred naming this trust as for Ginger as the beneficiary of his traditional IRA or his traditional 401k, very little or nothing may wind up going back to Fred's children because required distributions under the trust rules and under the surviving spouse rules may require Ginger to really deplete that trust solely as a result of required distributions. So with IRAs, a lot of Freds of the world, Fred and Ginger, each have 2 kids. To really simplify things, Fred may say, you know what? Here's what I'm going to do with my IRA. When I die, I'm going to leave 30% of my IRA to each of my 2 children. Let them get it right away. They don't have to wait till Ginger dies, and we don't have to go through all the complications of leaving an IRA to a trust. I know if I name Ginger as the beneficiary of my IRA, 100% primary beneficiary, she'll get it and she'll wind up leaving it to her kids. So tell you what, to keep it simple, Fred says, I'm going to leave 30% of my IRA to each of my 2 children, and I'm going to name my spouse Ginger as a 40% beneficiary. Yeah, she'll get the 40%, and if she wants to leave that to her kids, so be it. That's okay. I'm good with that, Fred says. So when Fred dies, each of the two children get their inherited IRA. They've got 10 years to take distributions from their inherited IRA and pay the income tax on them. But at least the children are getting a chunk right when Fred dies. That makes Fred feel good. That makes his children feel good. It takes a little bit of the pressure that the children may put on Ginger, or takes a little bit of pressure off of Ginger, putting it on his Fred's kids. Fred had $1 million IRA. The kids each get $300,000 when Fred dies. Yes, the $600,000 goes into Ginger's IRA, and maybe she leaves that back to Fred's kids, even though she doesn't have to, or she names whoever she wants to as her beneficiary, her kids, her favorite charities, her next spouse, her next significant other. But she might leave it back to Fred, but there's no guarantees of that. So, all right. So with IRAs, with other assets, or maybe I call it regular assets, houses, brokerage accounts, bank accounts, real common for a Fred in the world Fred and Ginger, who have kids from their prior marriage, real common for Fred to leave his estate in trust for Ginger, because there's no income tax consequences like there are when you leave beneficiaries of an IRA, and that principal can be preserved for Fred's children to get when Ginger dies. So, but with IRAs, it's a different story. You at least need to consider as an option, I'm going to leave some outright to my children and then leave some outright to my spouse. And that might make everybody happy. All right. So let me run through my kind of number 3, the case study that I want to report, just to give you an example. So let's say you've got a married couple. Let's stick with Fred and Ginger. They like to go dancing. Each spouse has 2 kids. And so they're each bringing assets into the marriage. Maybe Fred has $4 million and Ginger has $500,000, or maybe Ginger has $10 million and Fred's got nothing. So whatever the case may be, let's say they do that prenup, because generally they're thinking, Fred and Ginger are thinking, we're getting married later in life, and I'm bringing some assets into the marriage. And yes, we may spend some or all of it during our marriage, but Fred's saying, you know what, when I pass away, or when we pass away, I want to make sure my kids get what I bring into the marriage. And maybe Ginger says the same thing. They just feel like that's right, as many couples do. So that prenup is done not so much for divorce purposes, although it does apply if they get divorced. It's also for what happens when one of them dies. Let's make it easy to determine who owns what. So they each want their own kids to inherit. And so Fred sets things up. Maybe he says, if I die first, I leave some assets to my kids directly. They don't have to wait until Ginger dies. So maybe Fred does a combination of leaving some assets to his children the moment he dies, and he does that either in his will. So through the probate, the assets will go from Fred's estate to Fred's children. If it's in a living trust, whoever the trustee is when Fred dies will distribute trust assets directly to Fred's children right then. So the first spouse to die may leave some assets directly to their spouse right then. And then the first spouse to die might leave their assets to a trust to provide for their spouse, both income to their spouse and perhaps principal distributions to their spouse. But whatever is left when the surviving spouse dies in the first spouse to die's trust will revert back to the children of the first spouse to die. So they set all that up. They realize the IRA issues. Some couples say, well, my IRA is small, I'm just going to leave it to my spouse. Or they'll say, oh, my IRA is small, I'll just leave it to my kids. But having thought go into that is really important. Another issue is the whole, life support machines decision. So you want to get all that stuff in your healthcare documents set up appropriately ahead of time. Let's say Fred goes on life support. And so let's say Ginger says, you know what, she kind of barks at Fred's kids. Hey kids, I am Fred's wife. I don't care what Fred did. I get to make that decision on when Fred is taken off of life support. What she says, we don't get his big pension anymore when he died. Let's keep him on the life support. So there could be a situation like that. So you want to make sure, set everything up. The right people have the right authority to make all of the right decisions without conflict from others who shouldn't be involved in many of these decision-making processes. All right, so summing it up here before we go to the chat, the problem typically rears its head when the surviving spouse dies, but the problem comes from what happened when the first spouse dies. So in order to solve the let's not have chaos when the surviving spouse dies, you got to get all this stuff set up properly while both spouses are alive and well, because what happens when the first spouse dies has major consequences over what happens when the surviving spouse dies. So not only do all of the bequest things need to be set up right, the beneficiary designations, your executors of your will, your trustees of your living trust or other trusts that get established, your durable power of attorney agents, your healthcare document proxies, or whatever they may be called in your applicable state. All of that needs to have some careful thought, understanding what the potential consequences might be, making informed decisions, documenting those decisions, and perhaps even communicating to your spouse, to the children, not only what you did, but why you did it. And and a lot of that can solve some of those problems that tend to surface, when a surviving spouse has to deal with the children of their deceased spouse. All right, so let's jump over now to our chat. And again, Larry chimed in first. Fantastic. Tad and Johanna. Good to see Johanna. I've seen her before. Good evening. Ms. Mel, appreciate you sharing this very information. Thanks. And you gave me flowers. You made my day. I'm about to get emotional, Ms. Mel. Hopefully you'll be on future live streams. I think you're the first person to ever give me flowers on a live stream. So that's the chat of the day for sure. Johanna, looking so forward to this, as this is my situation. Fantastic. The Blender family and Ted. Yep, it's a difficult times. And just joking. Okay, good. Joke. Okay. I want to say there is a joke that goes with Blender family, and I just don't know what it is. I want to say I've heard that before, but maybe not. Brian, just wanted to say thanks. I just found this. You're welcome, Brian. Again, made my day. People like to save money. That causes problems at the end. A lot of truth to that, Anne. People do like to save money. I'm a big proponent of saving money, and I don't think you should not save money because it could potentially create problems at the end. I think people should save money, but I think they should address the potential problems that could happen. So that's a mouthful. I want to be fit. What if married later in life and one spouse has adult children, aren't on speaking terms, and other spouse never had children? Typical problem right there. So you've got married couple, one spouse has children. Apparently there's no speaking going on. Big problem there. All the issues that I addressed are now at play. So you may be one of those where you want to check out the description, click the link, and try to schedule an estate planning Zoom meeting with me so we can talk through that and perhaps set things up so there's not these big problems down the road. Nelbo says the boyfriend of deceased is designated as sole beneficiary in her living trust. Is that sufficient to obtain hospital information and access her PO box and safety deposit box if he finds the key? Thanks. All right, so boyfriend of deceased is designated. So a woman died. She has a living trust. He's the beneficiary. So solely as a result of being beneficiary, I say he has no access to anything. I'm wondering who the trustee, probably boyfriend, is trustee as well as beneficiary. And I'm wondering if she also had a will naming boyfriend as executor. If she did those things and he's confirmed as the executor, he can probably get in the PO box. He can get in the safety deposit box. Hospital information, not sure about that. There's HIPAA authorizations that you can sign authorizing your executors, trustees, or individuals to get access to your medical records even after you pass away. So I'd be taking a look at that if there's some kind of HIPAA authorization that authorizes post-death access. And he sounds like my situation. I want to be fit, good, and let's keep going here. I'm scrolling and I lost my thing. Let's see. Good. David, okay, I want to be fit. What if someone is older and have no surviving family? How is that handled? So if someone's older and they have no surviving family, so a lot more questions there. I want to be fit. Is that older person married? And so if they're married, there's issues. If there's not married, there's issues. And so how is that handled? Well, how is what handled? Who do they leave stuff to? So is that what you're asking? Who do they designate on their powers of attorney? Is that what you're asking? So, but you're implying that the older person just has no one in their lives, which may very well be the case. So when an older person just has no one in their lives, usually they have some people or some cause that they can appoint either as representatives or as heirs or beneficiaries. There potentially could be charities that are involved. So we just have to take those decisions one step at a time and help that person make the right decision. I hope I'm giving you an answer. And should you name stock and CD in the trust name instead of person in a special need trust? Not sure what you're getting at. Many people do leave their assets to a special needs trust if they have a beneficiary or a child who's has special needs and is getting certain government benefits, and leaving them assets directly would penalize them from getting those government benefits. So they leave it to a particular special needs trust, which supplements the government's care that the care provides instead of replaces the care that the government provides, all allowing that beneficiary to retain their government benefits. Jose, can I set up a trust with someone I'm not married to? It is permissible. So the can I and the should I, there may be two different answers to that. But I actually set up a trust one time for three siblings. None of them married. None of them had any kids. They all lived on in a piece of property together. So just if one of them died, they wanted their share to go to the other two, and the other two died, they wanted their share to go to the last surviving. And then I don't even remember what they did after all three of them die. But it is permissible that you can set up a trust with someone you're not married to. Is that the simplest, easiest, most efficient way to do it? Maybe, maybe not. So that would all depends on your circumstances and what you're trying to accomplish. Joanna, how to handle a home property when spouse dies, perhaps a trust leaving to be divided with the kids, but what is remaining spouse? Okay, so yeah, sometimes a house is left to a trust. And you're like, well, what if I leave it in trust for my spouse? I've got my kids as the ultimate beneficiaries. And what if my spouse wants to sell that house and downsize or upsize or whatever size, supersize? Well, if you're concerned about your spouse having the ability to sell that house, and let's say it's $1 million house, then when you die, that house goes into a trust and your spouse is the sole trustee of that trust. And he'd have the ability to sell it. So let's say he sells that house for $1 million. The $1 million goes into that trust. And then let's say your spouse wants to downsize. And let's say your spouse spends $600,000 on a new house. Now, in your trust, there's a new house worth $600,000 and $400,000 of cash or investments. And all of that stuff will wind up going back to your children or whoever the beneficiaries are when your spouse later passes away. But that is a way to enable your spouse to have that control over the sale of a trust asset, naming them as the sole trustee of that trust. All right. Are post-nuptials recommended if maybe, depends on what the two spouses are trying to accomplish, and is a postnuptial agreement the best way to accomplish what you're trying to accomplish. So, been involved in many postnuptial agreements, and we use them when we need to, just like kind of any other tool. Okay, so yeah, that was a good one. I've got another one tomorrow on a lot of, we talked about some power of attorney stuff today. Got another one tomorrow on the power of attorney issues. Good seeing all the regulars in there. I so appreciate your participation, your involvement, your comments, your questions. You all have a great evening, and we'll see you next time. Make sure you subscribe and like so that we keep this puppy going. See ya.